which is House Bill 122, Fees for Government Records Requests. Representative King, welcome.
Thank you, Mr. Chair. It's a pleasure to appear before you. This is sort of an interesting little bill. I had the pleasure, it was a pleasure to serve on the study group that was formed after the HB 477 circumstances that we had a couple of years ago. And we have some new members of the committee, so I don't want to. Boy, we got a lot of new members of the committee. Shoot, we got more new than old. Well, no, Representative Westwood, you are more than good looking, let me tell you.
Yeah.
No, I'm calling you good looking, Representative Seelig.
Don't get any votes.
Yeah, that's okay.
Yeah, point of order.
So back 2 years ago, we had in the spring, in the last days of the session, it was probably about this time in our session in 2011, there was a bill that dealt with GRAMA that came before us. It would make some significant changes to GRAMA, passed easily. People got excited, the media got excited, and it ended up being basically rescinded by the legislature shortly after that. You all know that. But one of the things that was formed right after that you may not be quite as knowledgeable about or aware of is that we formed a working group. And the working group was met during the interim period. I think we started in like May of 2011, and we went through something like September, October. And the working group consisted of some legislators, and Senator Bramble was on there, I was on there, a lot of folks from the media, and a lot of folks from other circumstances too, technology people. Great recommendations. You can find the recommendations from the GRAMA working group. I don't know if they're still on our legislative website or not. They were on the legislative website for a long time. But one of the things that came up and that we talked about was the question about fees. What do you do when you deal with fees that are required to be paid by requesters? And so I took a closer look at that. The working group ended up not making any recommendations one way or the other about that. But if you look at the bill, this is a very straightforward bill that addresses that aspect of GRAMA, and it's right there on lines 56 and 57. That's the only change the bill makes. Currently, the statute says that a governmental entity may fulfill a record request without charge and is encouraged to do so when it determines that, and there are three criteria. The one that is most commonly crops up as being a basis for a request for a waiver of the fee is the first one on line 58. Releasing the record primarily benefits the public rather than a person. So what you have under current law, and what would remain true under the bill, is that the governmental entity that receives a request makes an initial determination about whether the request is primarily in the public interest or benefiting the public rather than a personal interest. Under current law, if the governmental agency determines that it is in the public interest, they're encouraged to waive the fee, but they retain discretion to not do so if they choose not to. Here's the concern that the reason that I brought this bill. I've heard back from many people who say there is undoubtedly a primary public interest in our request for records. But what you have is the government agency even acknowledging that and then saying, you know what, though, we have discretion, and we're going to say no. So you have, in other words, some inconsistency between what our government entities are encouraged to do, namely waive fees when they determine that releasing the record primarily benefits the public, and what they actually in practice do. What they in practice do is routinely say, we're not going to waive. Well, I thought that the best way of dealing with that, and the most straightforward way of dealing with that, and the way that would encourage greater transparency and greater participation by the public in what we do as public servants and as government officials, is to just continue to leave it in the hands of the government agency to make the threshold determination about whether the fee request or whether the record request is primarily in the public's interest. But once that determination by the government agency is made and that it's in the public's interest, you just say it'll be waived if that request for a waiver is made. So it's not much of a change in some ways from what our state agencies should be doing now. And it's an interesting thing, the state agencies that I've heard back from basically say, yeah, we do get a lot of requests for records that we know are, or that we would acknowledge are primarily in the public interest, and we don't waive in response to requests for waiver. We don't waive many times right now. Sometimes we do, but many times we don't. And so there's going to be some cost associated with this. That's why you have a fiscal note, because there will be some cost in the estimation of the LFA. But I would suggest to you that the larger the fiscal note is, the more of a problem there is, because it shows the inconsistency between what we expect our state agencies to do and what they're actually doing. So what I'm doing is making the statute a little more straightforward, a little more streamlined, and I think complying with the intent of the legislature when we passed GRAMA back in the 80s to provide greater transparency and greater involvement, public involvement in getting access to public records.
Thank you, Representative King. You have a question from Representative Webb.
Representative, this isn't about providing the information, is it?
It's about providing it's about providing individuals with greater ability to get access to records without having to pay for them.
But the government entity is required to fill the request. Is that correct?
Sure, but individuals are deterred many times from making the request, or from, once they get a cost estimate, following through and paying for getting the public records when they see what the amount charged is, when they see what the amount that they would have to pay is.
And I think I understand the direction you're going.
So, I mean, Representative, I have no problem at all with a state agency that says, in our judgment, your request is primarily for a personal interest or a private interest, therefore we're not going to waive the fee. My bill doesn't affect that. Those individuals will have to pay. I mean, when you want to get records of your employment history because you're thinking about suing your employer or state agency for discrimination, employment discrimination, you got to pay. That's not a public interest in my mind.
So, just to clarify, this is not about providing the record. This is about having to pay for the record.
Right.
And so, there's some discretion built into the code currently, where if you've got a small city, for example, who has numerous requests, they may undeniably, all of them, in some way or another, be able to be characterized as being in the public interest. And so the law as it currently reads says that you may have a number of those requests, but the discretion as to whether or not those records will be provided without cost rests with the city, and that's the discretion you want to take away.
Well, I want to take away the discretion to deny a request for waiver of the fees once the city determines that it's in the public interest, that the public interest outweighs the private interest. That's right.
Okay, thank you.
Okay, thank you. Another question. Representative Hall.
Thank you. I appreciate this, the bill. I just have a couple of questions. You state that the government entity will still have the decision-making ability as to whether it primarily benefits the public rather than a person. I guess my first question is, what guidance do we have on how the government entity determines that?
You know, that's a very good question, and I can't tell you that I know off the top of my head the answer, Representative, but I have a feeling I could be wrong about this, but I have a feeling, and it's just based on my recollection from going through the working group, it's not in connection with this particular bill, that there is rulemaking, there is Utah administrative rules that address that question, and that the state agencies routinely and regularly go through the process of evaluating that based on criteria that isn't outlined specifically in GRAMA, but that does exist.
Mm-hmm.
And I don't have any desire or intention to affect that.
I don't know, maybe there's some case law that helps in
There
that
might be.
regard.
There
I
might be.
Don't know. Maybe there's no case law because in every case the city or county or governmental entity just goes ahead and denies it based on the May language.
Yeah, and I don't want to, look, our state agencies are not big bad ogres. I don't think they do routinely and unequivocally deny them.
Well, and not deny the request, but deny the waiver of
Right,
fee.
and I think they'll waive at times. I think that that's not infrequent or uncommon, but what my sense is that more often than not, even though there's a determination made that it's in the public interest, they will deny. There may also be, to answer your question, some information and some guidance provided by the State Records Commission.
Okay.
Go ahead.
Sorry, the second question I have is that this fee waiver would also apply to 4B, right?
Oh yeah, and it would.
I'm wondering if 4B might be abused in any way if we have, several individuals who may think to themselves, well, I want to know what the state has on me, or I want to know what the city has on me, and there's no deterrent, even if the request is unreasonable. There's no deterrent. At this point, the municipality has the, discretion. If the record request is unreasonable with respect to 4B, they could deny the fee waiver, but what are your feelings with respect to 4B and whether or not 4B would be abused?
Well, that's a fair question, and you're right. 4B and 4C, lines 59 through 62, are subject to the same change in the statute that the bill proposes, that line 58 is 4A. So it's something we have to deal with. And is there potential for abuse? This is one of the things that state agencies, in talking to me about the bill, have expressed some concerns about. There is potential for some abuse, and the process exists within GRAMA today for an appeal to be made when there are decisions made about whether to release or not a record, or whether a record is protected, or whether a record is confidential, or whether a waiver of the fee is going to be granted. Those decisions are, when there is a grievance and those decisions are appealed, there is a process in place under GRAMA today to take those up, if needs be, to the Utah State Records Commission. So I think there's a framework in place to already to deal with that.
Thank you.
Okay, moving on to the next question. Representative Westwood.
Thank you, Mr. Vice Chair. Thank you, Representative. Appreciate your time here. I'm just wrestling with these words. It seems like to me a governmental entity may fulfill a record request without charge, and it's encouraged to do so when it determines that. To me, those are okay words, I guess. I'm not understanding directly what you're after right there. I'm sorry.
No. It's a fair question, Representative Westwood. Here's what I think is the problem. It would seem to me that if the state agencies are complying with the letter and the spirit of current law, what you would find are relatively few situations where government entities determine that releasing the record primarily benefits the public rather than a person, and do not waive a fee request. because they're encouraged to do so when that circumstance exists. So that's the ideal. Now, that's not to say that every time a governmental entity makes the determination that releasing the record primarily benefits the public rather than a person, you're going to see a waiver, because there may be circumstances where we'd all sit around and agree, oh yeah, under these circumstances, for one reason or another, they shouldn't waive. But the troubling thing to me is that from information that I get from people who routinely request records is it's more common than not that even when the governmental entity acknowledges that the request for records primarily benefits the public, they don't waive the fee. So the concern that I have is the difference between what the language says under current law and what is actually happening. Another way of putting it is, I'm concerned that what we're seeing is too many situations where the governmental entity is abusing its discretion. We've granted them discretion. We want them to act in good faith, but they've gotten in a habit and the practice of saying, we have discretion. We can do whatever we want. And so we're going to say, even though it's a public record or in the public interest, we're not going to waive the fee. That's a problem from my perspective.
Yes, it is. Thank you.
Okay, we have another question from Representative Dunnigan.
Thank you, Mr. Chairman. This applies to local government as well as state, is that correct?
Yeah, it's true.
Do you know how we define public, primarily benefits the public? What does that mean?
Well, we talked about that a little bit earlier. I think that there is criteria that's utilized by state agencies in making that evaluation. I don't think it's in GRAMA specified or laid out with any greater detail than what we've got in front of you, but I could be wrong about that. But I do think that it's laid out in the Utah administrative rules or some other well-recognized and acknowledged criteria that the governmental entities use to evaluate that, because they have to do it every day. I mean, this is something that's routine from their perspective.
Okay, thank you. So I have some concerns. One is for local governments. I guess it's nice to say that they should provide it for free, but they may not. That may challenge the resources. There are many, many GRAMA's requests, both to the state and to local government. And as was pointed out by Representative Webb, we're not saying that people cannot get those records or have access. We're simply saying that somebody has to pay for it. There's a definite expense and a cost to providing these records. And perhaps there should be some responsibility for those who are requesting it. And I just don't see what's wrong with the current language. The government entity may, is encouraged to do so when it determines that basically the public is benefited. So it's not really a question, but appreciate your comments.
Okay, thank you, Representative. Let's go to the public. Is there anyone that would like to speak to this bill? Come forward, please.
Lynn Pace, speaking again on behalf of the League of Cities and Towns. We reluctantly speak in opposition to the bill only because I've spoken with Representative King and tried in vain to find a solution that would work. As Representative Dunnigan mentioned, there is a tangible cost of responding to these GRAMA requests, particularly for local government. One is just the cost of the copying. The more significant element is the cost of the staff time responding to the request to assemble and gather the documents. And the challenge we have here is that if you broadcast in advance that whatever you ask for is free, then the request will become larger because there'll be much more that they want. And we've actually had this problem in certain instances. In Salt Lake City, we've had a protracted litigation over what is supposed to be a sports complex over on the west side of by the Jordan River. The documents requested were at least alleged to be in the public interest. Salt Lake City voluntarily produced at no cost 8,000 pages of emails from one individual within the city. The request was for about 20. And we said, please look through those documents. We think that captures the lion's share of what you want, but then tell us what else is missing, pare down your request, and we'll respond. They refused to do so because the tactic wasn't really document gathering. It was litigation strategy and delay and obstruction, which suited their purpose. In a similar instance, there was a document request made to the town of Alta for certain water records. The town of Alta estimated that in order to respond to that document request would require hiring a full-time employee for 1 year to assemble and collect and produce all of the documents. If you broadcast that they can have all of that for free, it is crippling to local government. So you've heard enough. We think the language of the statute is intentional and appropriate to say that the discretion needs to reside with local government depending upon the nature of the request, and that they are encouraged to do so. But leave that discretion with local government, because we need to have that flexibility to respond to the requester and the nature of the documents requested.
Okay, thank you, Mr. Pace. Anyone else that would like to speak? Okay, seeing none, Representative Seelig.
Thank you, Mr. Chair. I'd like to reserve the right to make a motion, I suppose.
That is in order.
Thank you. I appreciate the good sponsor bringing the issue to us today, and I actually agree with him. I think that we do have an issue here that needs to be addressed. However, I also appreciate the comments from the good committee members hitting on some of the variables in solution gathering, as well as the testimony, bless you, from members of the public. So what I would like to move is that we send House Bill 122 back to rules and request that the bill be placed on interim study.
Okay, thank you. Discussion to that motion. Okay, seeing none, Representative King.
Thank you. You know, I appreciate the comments from some of you as committee members, and I appreciate the comments from my friend Lynn Pace. I have a good working relationship with him and with the folks at Salt Lake City. And one of the things we heard about on the working group was situations where you have vindictive or crazy requesters. I mean, they're out there, and they can cost, especially our local and municipal governments, they can be burdensome. So I don't have a problem with the idea, with the motion, in the sense that I think if there are ways that we can tweak this and refine it a little better to work out some of the dispute resolution mechanisms, put in place maybe something that, you know, if the government agency believes that this is going to be unduly burdensome or onerous, that, you know, there be some way of dealing with it within the GRAMA or within the State Records Commission process. I don't have a problem with that. I think it's important, though, that we evaluate and recognize the degree to which what is currently happening when requests for records come in that undisputedly are records that primarily benefit the public rather than a person. That's inconsistent. What is happening, rather, is inconsistent with what the plain language of the statute says when it encourages our governmental entities to release those documents free of charge if that governmental entity acknowledges that they're primarily in the public interest. So I don't have a problem with the motion.
Okay, thank you, Representative. Representative Seelig for some.
Waive.
Okay, thank you. Let's just do a voice vote on this. The motion before us is to send HB 122 back to rules to be placed on the master list for interim study. All those in favor say aye. Aye. And all those opposed say no. Thank you. That is unanimous. Thank you, Representative King.
Thank you.
Senator Weiler. The suspense was killing us.
Well, I had my intern here, I had Adam Troop here, and I was in business and labor doing liquor laws and hair braiding, so
At the same time, or?
thank you. What's that?
At the same time?
Pretty much.
In the same bill?
Thank you. Senate Bill 145 is mostly a cleanup bill. What we have is the current statute has the duties of a county and district attorney, the duties of a public prosecutor, the duties of civil counsel, and other duties, all intermingled, like if you had thrown them into a blender or a tossed salad and just mixed them up. And so what this bill does is it separates them out into their each section. So all of the duties related to a county and district attorney are together, and then all the duties related to the other ones are together. So, and then it also has a new ethical provision that, with the chair's permission, I'd like to have Adam Troop testify to. And then one other point, because I'm hoping that the committee will make a motion. On the floor of the Senate, Senator Valentine proposed and passed an amendment that is on line 167. He added the words "at will." We have since determined that would basically make every elected county attorney in the state at will, which was never the intent of the bill. And so I'm hoping that one of you at the end of our presentation will move Amendment 2 to strike out those words. Senator Valentine agrees that that was an ill-advised move. So if I could, I'd like to turn the time over to Adam Troop from Salt Lake County.
Okay. Mr. Troop.
Adam Troop with the Association of Counties. Thanks. Glad to be back.
Association of Counties, I'm sorry.
That's all right. Let me speak, if I may, to the amendment, actually. First, the concern with the at-will provision is that it doesn't, in fact, apply to all county attorneys. It only applies to one. And under the Utah State Constitution, the district attorney has to be an elected county official. And so there was, I think, a mistake in understanding about what we were doing in this bill, and that it appeared we were creating a different contractual arrangement that was possible for a district attorney. We are not doing that, and in discussion with Senator Valentine, he's comfortable with that amendment. So as to the amendment, that's our primary concern.
Okay, does that conclude your presentation?
Yeah, it does. I'd be happy to answer any questions.
Okay, we have one from Representative Dunnigan.
Thank you. I move to amend
That is in order.
line 167 of the Senate amendments to strike the two words "at will."
Or you could move Amendment 2. I think it's ready. So.
Okay.
Oh, yeah, we've got an amendment.
I move Amendment 2.
Okay, we have a motion to move Amendment 2. Discussion to that motion. Representative Weiler.
Thank you for the promotion. I don't have anything
Senator?
further to add.
Thank you, Senator. Representative Dunnigan. Waive. Okay, the motion before us is to amend with Amendment number 2. All those in favor say aye.
Aye.
Any opposed say no. Your bill is amended.
All right, and really that is the bill. Did you touch on the ethics provisions of who the client is?
No, I did not.
So the only substantive change it makes, other than reordering into a logical sequence, is it clarifies that who a client is for a district or county attorney, because there have been some court decisions that have cast some ambiguity on that. So it adds that clarification.
Thank you, if I may, Mr. Chair. I don't have too much to add. The senator has actually explained the bill well. Really what we're trying to do as we go through this process is to clean up the code some, to create consistency and understanding across sections. We're not trying to create any new rights or authority, but simply to be a piece of clarifying legislation. So we'd appreciate your support for this.
And the ethical duties start in line 360. And it says an attorney exercising public prosecutor duties is a lawyer representing an organization as a client under the rules of professional conduct. They represent the state as a client and is considered a representative of the state. So that's really the only substantive part. I hope this committee would find reason to pass this out favorably.
Okay, looks like we have someone who wants to speak to that. Representative Dunnigan.
Thank you, Mr. Chairman. I move that we recommend Senate Bill 145 favorably.
That motion is in order. Would you like to speak to that?
No.
Okay. Representative Weiler.
Representative again, I waive.
That's what you get for showing up late. All right.
Jay.
Okay, the motion before us is to pass out SB 145 with a favorable recommendation. We will do
as amended, I hope.
As amended. We will do a roll call vote. Yes. Yes. All right. Well, thank you very much, Senator.
Thank you.
Looking for one more motion. Representative Paulson.
Motion to adjourn.
Motion to adjourn. All those in favor say aye. All opposed, say no. We're adjourned.